In the last month, state and federal Wisconsin courts have made several important rulings affecting voting procedures. It's a lot to keep track of with only a month to go before the general election. Hello, I'm Jeff M. Brown, legal writer with the State Bar of Wisconsin. With me here today to wade through two of those court rulings is Mike Haas, Madison City Attorney. Mike will be one of the presenters for the State Bar's Elections Law CLE, which will be held on October 12th. Welcome, Mike.
Welcome. Thank you, Jeff. Good to be with you.
Good to see you again. Mike, the Wisconsin Supreme Court in July issued a decision that invalidated the use of ballot drop boxes and said that voters must return their own ballots in person. Can you walk us through that decision and talk about what it might mean for the city of Madison and other municipalities across the state?
Well, sure, Jeff. I mean, the Teigen case is sort of a reminder of what we went through in 2020 when Wisconsin municipal clerks were conducting elections in the midst of a pandemic. And also, by the way, with a lot of discussion that year about the Postal Service and delays in returning ballots, absentee ballots, all across the country. And so Wisconsin clerks really, in the Wisconsin Elections Commission, dealt with those challenges and ultimately determined that voters that were delivering absentee ballots could do so by placing them in a drop box located across the community. And in Madison, we had a number of those drop boxes. The Wisconsin Elections Commission issued guidance stating that that was an acceptable way to return ballots, even though it was not specifically addressed in Wisconsin statutes, which merely state that the ballot needs to be returned by mail or personally by the voter. So a court case was brought, ultimately ended up in the Wisconsin Supreme Court this year, and the court determined that those drop boxes were not allowed under Wisconsin law. It declared that voters must return absentee ballots by mail or personally, meaning themselves, not by a family member or by a friend. And it could be delivered, it must be delivered personally to the municipal clerk's office or to one of the in-person absentee voting sites. So this was an issue that was of course, has been talked about across the country and in Wisconsin over the last couple of years. There was no challenge to absentee ballot drop boxes leading up to the 2020 election, but it has been included in a number of the lawsuits challenging the results of the election after the fact. So municipal clerks often have to implement decisions of the courts, of course, related to elections. We hope those do not come too close to the election, but in this case, the court said drop boxes could only be used if they were supervised, meaning essentially in the clerk's office with staff in view of the drop boxes. So in the city of Madison, our drop boxes are secured, but they're located across the city at fire stations, mostly where there are cameras that monitor them. So under the court decision, the city of Madison will not be using those drop boxes, did not use the drop boxes in the August primary. And so communities around the state will need to certainly adjust to the court decision and make sure that only drop boxes that are supervised are being used for the return of ballots.
I know what you mean about the fire station. There was, I should say, a drop box in front of the fire station just down the road from us. I see it each morning on our walk when my wife and I go on our walk. What about, there was a lawsuit about this too, or at least some controversy about this, the event that was held in a city park in Madison where people came and dropped their ballots off to, I believe, what were city employees. If they weren't, is that something the city is considering going forward, having events like that where there will be staff from the clerks, which would seem to comply with the ruling for people to come and drop their ballots off?
Well, that was, of course, Democracy in the Park, which also received quite a bit of attention. Again, another election activity that was not challenged before the 2020 election. But then did become a focus of some of the lawsuits and litigation after the fact. Madison is not going to be using those events this year. And the only reason really that it did in 2020 was again because of COVID and because of the concerns about the concerns about delays in returning absentee ballots through the mail. And so Madison had at every one of its, I think, 200 city parks on 2 consecutive Saturdays had sworn election officials collecting ballots in a secure way and returning them to the municipal clerk's office. So that was sort of a unique event for that time period. And the clerk's office has not entertained, plans to use those events this year.
So a federal judge, a month after the decision we just talked about, a federal judge here in Wisconsin ruled that disabled voters are entitled to have someone return their ballot for them. The basis for that was the judge's interpretation of the Federal Voting Rights Act. Is there any conflict between that ruling and the state Supreme Court ruling from July about drop boxes? And if so, how is the city and other municipalities navigating that and deciding, who can get help with their ballots and who can't?
Sure, that was the Kerry case, the federal court decision. And it's interesting because in the Teigen decision, the Wisconsin Supreme Court somewhat took a pass on the issue of accessibility laws and how federal accessibility laws and how they might impact the return of absentee ballots. And the court said that it was not fully briefed, and so therefore the court was not going to take up that issue. There was then a subsequent federal court decision, and Judge Peterson ruled that the Voting Rights Act preempts state law to the extent that state law might prohibit voters with disabilities obtaining assistance from third parties to return their absentee ballot. So the court indicated that federal law guaranteed that voters with disabilities had the right to vote and the right to return their ballot, and in doing so could obtain assistance from other individuals to either mail their ballot or to have it returned to the municipal clerk's office. There was a lot of concern amongst the election officials about voters with disabilities just simply not being able to get out to the mailbox or get in the car and deliver their ballot on their own. And in Wisconsin, I mean, our tradition, I always say, of being Wisconsin nice, I mean, helping out your neighbors. Under the Wisconsin Supreme Court decision, there was a real question about whether or not that would be permitted. And the federal court clarified that federal law did guarantee that right. So I think that it was a clarification. I don't know that there's really a legal conflict at this point. Municipal clerks will be implementing the federal law and ensuring that voters with disabilities are able to return their vote. Of course, that's always, on a case-by-case basis. There isn't any documentation or verification that's going to be requested, certainly by our clerk in Madison, that a ballot that is being returned is from a voter with a disability. It's just will become part of the administration of the election.
Okay, great. So a lot to unpack in those two decisions and several of the other ones. It'll all be discussed by Mike and some of the other presenters at the State Bar's Elections Law CLE on October 12th. Look forward to seeing you there, Mike. Thank you for the time today.
Thanks. Looking forward to visiting it with everybody.
Okay, see you then. Bye-bye.
Bye.